Good afternoon, everyone, and welcome to the CECA and Bevan Brittan Employment Law and the Employment Rights Bill webinar. That were a bit of a mouthful. My name's Jennifer Patel, and I'm Business Support Officer for CECA, Yorkshire and Humber. And we're grateful to our friends at Bevan Brittan who are going to be delivering today's webinar. Just as a little bit of housekeeping, you can use the chat function or the Q&A function if you do have any questions. And our colleagues at Bevan Brittan will be happy to take any questions at the end of today's session, providing we do have that time. I will send out a copy of slides to yourself for your own records after, and the webinar today is going to be recorded, and a recording of the webinar will be uploaded to our YouTube channel. So when I send you a copy of the slides, I'll also email you the link for that as well. If anybody does want a certificate for CPD purposes, then you can contact me directly to ask for one of those. But for now, I'll hand over. So thank you very much, and I'll hand over to yourself, Lee. Thanks all.
Thank you, and good afternoon, everybody. And thanks for inviting us along to speak to you today on today's topic, employment law and the Employment Rights Bill. My name's Lee Carroll, and I'm a partner at Bevan Brittan in the National Employment Pensions and Immigration team. And I'm also based in Leeds, so it's a pleasure to be supporting a local CECA session today. Do you want to move to the next slide, please? Thank you. So over the course of the next 60 minutes, you'll hear from two myself. The slide on the screen there contains all of the contact information of your speakers, together with a QR code which will direct you to their LinkedIn profiles. Please do feel free to get in touch, link in with any of them, and contact any of the speakers. So first up, you'll hear from Siobhan Mulry, who is a legal director in our Birmingham office. And she is experienced in acting for a wide range of employers in the commercial sector, education sector, independent health and social care sectors. And she'll discuss some of the reforms arising from the Employment Rights Bill. Following Siobhan, we'll then have Helena Morrissey, who will deal with some of the other parts of the Employment Rights Bill, and then talk about some other reforms that are in the concept stage. Helena is also a legal director. He covers a full range of employment law topics, from large-scale, complex project work such as TUPE transfers, restructures, redundancies and change management, to day-to-day HR issues. And then finally, I'll be taking you through 3 recent employment law cases. Following our talk, there'll be time for you to raise any questions that you might have, stick them in the chat or the Q&A function, and we'll do our best to get to them. Next slide, please. So I start this session by reflecting on 2024 and what a year it was. So in July 24, we had a change of government, and with that came a raft of reform proposals promised by the Labour government's Change Manifesto. And those reforms align with its plan to make work pay, delivering a New Deal for Working People paper, which was published in May 2024. The reforms have been heralded by Sir Keir Starmer as the biggest upgrade of workers' rights in a generation. The Change Manifesto promised to introduce an employment rights bill within 100 days of the Labour Party entering government. And true to the word, on day 100, an employment rights bill is what we got. And this is a colossal piece of legislation, 158 pages in total, setting out a total of 28 reforms, including things such as providing day one rights to employees, better trade union access, and then some hefty new rights in relation to 0 and low hours workers. You'll be pleased to know that we're not going to go through that legislation line by line today. The reforms are huge, but they leave a lot of the detail to secondary legislation, which has recently been through consultation, and we're awaiting the outcome of those consultations in the near future. The bill's been supplemented also by a further 58 pages of amendment, clarification and further reform. And just last week, we had further proposals to amend to include new obligations on employers to take reasonable steps to prevent workers from experiencing domestic abuse in the course of their employment. Question is this all too much too soon? Well, certainly a report by the Regulatory Policy Committee, that's the parliamentary watchdog, in November 2024, branded 8 of the government's 23 impacts assessments as not fit for purpose, which suggests that more thought is needed before we can fully understand the impact of the reforms. And on that note, it's probably right that I issue you with a disclaimer now. Our discussion about the reforms today is based on what's available right now, and that, of course, is subject to change as the bill progresses through Parliament. But based on the current position, there are some clear winners and some clear losers too. It's probably no surprise that the reforms are great news for employees who are set to gain better job security and protections. This is particularly good for those who are in what may be described as low-paid occupations, such as health and social care, hospitality and retail, who are going to be most affected by the reforms. There are over 10 million people working in low-paying occupations at the moment. The reforms to unfair dismissal are going to be good news for over 9 million people who typically work for their employer for fewer than 2 years service. 2 years, sorry. The reforms to parental leave are going to see 1.5 million working parents eligible for unpaid leave. And trade unions are also the big winner with the repeal of some of the previous government's legislation, which placed restrictions on their ability to undertake industrial action. The reforms are less great for employers who are going to shoulder the increasing costs and administrative burden that will come with the implementation of these reforms. The government suggests that the cost to employers is in the low billions of pounds annually, which they say is going to be less than 5 billion. That assessment isn't shared by others, and that Regulatory Policy Committee paper said that the government's assessment is very much a rough estimate and could be way off the mark. And there is also concern that those costs will simply just be passed on to workers through lower wages, less recruitment activity, and a search for more automation. The particular losers in this, bad news for the employment tribunal system. Now, government statistics confirm there are currently 444,000 claims live in the employment tribunal system. The system is already creaking at the seams. And it's estimated the impact of this bill will result in an increase in claims by about 15%. So what can you do to plan for these reforms? Well, you'll be pleased to know that you've taken a positive step by being here today and listening to us. We're going to continue to scrutinise the reforms as they make their way through the legislative system, so we'll keep you updated. This is a shameless plug to encourage you to join our mailing list. In addition, please know that we are here to support you in getting ready, whether that's with reviewing your policies or auditing your systems, providing training to your managers, or advising you how to manage the impact of the reforms on a practical level. And with that introduction, I'm now going to hand over to Siobhan, who will take you through some of the reforms.
Thank you, Lee. Now, as Lee said, we are dealing with a colossal document, which is 158 pages long. So there is an awful lot for us to get through. This is going to be a bit of a whistle-stop tour of what's in the Employment Rights Bill and some of the key changes, key proposals rather, that you need to be aware of. So probably the one which has caused the biggest stir is the day one unfair dismissal rights. The government has confirmed that these changes are due to take effect no sooner than autumn 2026. This is to allow enough time for the government to undertake a full consultation on the changes and to allow employers sufficient time to prepare. So there is time, although it will come round quickly, no doubt. Currently, employees must, as you're probably aware, must have at least 2 years continuous service in order to bring an ordinary unfair dismissal claim. So the proposal is that this will be repealed and unfair dismissal will become a right from day one of employment. However, the government has said that it does recognise the importance of ensuring that someone is suitable for the job. To address this, the bill does refer to an initial period of employment, which is essentially a statutory probationary period. the proposal is that it will be possible to dismiss new hires during this initial period of employment, so long as the reason for the dismissal falls within one of the prescribed fair reasons, and those are conduct, capability, statutory restrictions, or some other substantial reason, provided that those reasons relate to the employee. So this does mean that employees will only truly be protected from day one for redundancy dismissals or dismissals for some other substantial reason if the reason is unrelated to the employee. It is anticipated that the regulations will set out some sort of dismissal process during that initial period of employment, which is likely to include a meeting with the employee, probably a meeting at which they would have the right to be accompanied. The next steps paper, which the government has published, also refers to this being a lighter touch process than your usual dismissal procedures, although it isn't clear at the moment how it's going to operate in practice. The government is consulting on what the length of that initial period should be. However, that next steps paper has suggested that it will be a 9-month period, which is slightly longer than you might be used to in a typical 3 to 6 month probationary period, which typically we'd see within an employment contract. The bill does clearly state that the right to claim unfair dismissal will not apply to employees who've not yet started work, subject to some narrow exceptions. So how significant will this reform be? Well, we've established that unless the dismissal is for a reason unrelated to the employee, it's unlikely to be a true day one right. However, the impact of removing that 2-year qualifying period of service for unfair dismissal claims could still be very significant for businesses. In our experience, many businesses do exercise caution when dismissing employees, regardless of whether they have qualifying service or not, being alive to other risks of claims in relation to claims such as discrimination, which don't require qualifying service. However, there's no doubt that it will be harder for businesses to dismiss new hires during that initial period of employment than is currently the case, and harder still outside of that initial period of employment. So businesses are likely to want to ensure that you have robust recruitment procedures in place, as this will be key to ensuring, as far as possible, that new hires are right for the job before they're taken on. And it would be worthwhile having a look at your recruitment procedures now in readiness for this change. This change might also encourage some employers to consider using temporary agency workers as opposed to permanent hires. No doubt that wasn't the intention of the government's proposal, but we can see that as a way in which many businesses will try to avoid these rights applying. There will be a much higher percentage of the workforce who will be entitled to bring unfair dismissal claims, and there is likely to be a marked increase in tribunal litigation. I'll also mention here that the non-renewal of a fixed-term contract is regarded a dismissal in law. So there's going to be a question mark around individuals who are recruited for a short fixed-term project that may be less than 2 years. Will this legislation apply to them? Will they have unfair dismissal rights? And what will be the consequences and the procedure to adopt? So that will be an area to keep an eye on moving forwards. Further day one rights, which are introduced with the Employment Rights Bill, are various reforms relating to family-related leave, including making parental, paternity and bereavement leave day one rights for employees. Unpaid parental bereavement leave will not only become a day one right, but it will also become a right to more general bereavement leave, which will apply to the loss of a wider group of persons. It often comes as a surprise to many employers that actually there is no entitlement under legislation generally for bereavement leave when someone close to them dies. Of course, many employers do have that within your own policies and procedures, but this will now, or the proposal is that it will be enshrined in legislation that there will be a right to take bereavement leave. In relation to flexible working, the Employment Rights Bill will build on changes which were brought in by the previous government, which made the right to request flexible working a day one right for employees back in April last year. Labour's plan states that flexible working would become the default, except where it is not reasonably feasible, which in summary means that it's going to be harder for an employer to refuse a flexible working request moving forwards. There's also a proposal to make statutory sick pay available from the first day of illness rather than 3 days in. And it'll also be made available to workers that earn below the lower earnings limit, which is currently £123 per week. The bill also creates the Fair Work Agency, which will cover enforcement of statutory sick pay, national minimum wage and holiday pay, amongst other employment rights. The most significant of these is the enforcement of rights in relation to holiday pay, which is not previously been under the jurisdiction of any enforcement agency and is a notoriously complex area of law. It's worth me mentioning here, which Lee touched upon in the introduction, but we haven't included a vast amount of detail because it is hot off the press. But just last week, on the 29th of January, a further amendment to the paper was published. The new amendments are not yet part of the bill and will need to be agreed by Parliament. We're at the report stage, so they could be included or they might be voted down. But the key provisions are domestic abuse victims leave. So this amendment would entitle workers who are victims of domestic abuse the right to take leave from work. Although we await the draft regulations to determine exactly how this new right will work in practice, it is expected that leave will be for a minimum of 10 working days. The amendment also states that employers will be required to take all reasonable steps to prevent their workers from experiencing domestic abuse in the course of their employment, and employers with 5 or more employees will be required to have a policy outlining the support offered. So that's quite a significant change and something which is brand new for employment law and one definitely to keep an eye on. There'll also be an introduction of remuneration for carers' leave. So at the moment, there is an entitlement to 1 week's unpaid carers' leave, but the amendment suggests that that will include pay. There's protected paternity or parental leave will be introduced, and then also significant increases in family leave related pay. So that's the likes of statutory maternity pay, statutory paternity pay, shared parental pay, etc. There is also an amendment which has been introduced to include the right to take kinship care leave. So kinship is described as an arrangement whereby a child is raised by a friend, relative or extended family member other than a parent. And there's a proposal to extend the statutory parental bereavement pay to those who, to parents who are also bereaved by pregnancy loss, and not limited just to child loss. Unrelated to family-friendly rights, the proposed amendment also includes an extension of the protection for whistleblowers. So it will be easier for an individual, a whistleblower who has been unfairly dismissed, to make a claim after raising a protected disclosure, and the right for an individual to be accompanied to a disciplinary or grievance hearing will be extended to include a person who is certified by a professional body. Moving on now to dismissal and re-engagement, or as it's more commonly known, fire and rehire. So just by way of a short summary, for those of you who aren't familiar, this is a practice whereby an employer that's unable to agree changes to its terms and conditions of employment with its workforce dismisses the workforce and subsequently offers re-engaging them on new and often less favourable terms. You'll have all heard in the press the scandal of around the P&O ferries in 2022, during which time the fire and rehire practices came under particular scrutiny. So in that case, P&O Ferries used this practice to dismiss 800 of its employees and replace them with lower paid agency staff. The government has said it's committed to end the practice of fire and rehire as a lawful means of changing an employee's contractual terms, and the bill therefore includes a claim of automatically unfair dismissal for an employee who's been dismissed for refusing to agree a change to their contract of employment. However, the government does accept that where there is genuinely no alternative, businesses must be able to restructure and remain viable, which may involve dismissal and re-engagement practices. So there will be very limited exceptions to the ban where this practice could be used. It's important to note that as well as impacting typical redundancy and reorganisation scenarios, the new rules might, as currently drafted, impact intentions to vary a single employee's contract and may adversely affect an employer's plan to harmonise terms and conditions after a TUPE transfer. It's unclear whether this was the government's intention, so we do wait to see what the remit of this reform will be when it comes into practice. The use of 0 hours contracts has been somewhat of a contentious topic for a considerable period of time, and the Labour Party made its position on 0 hour contracts clear ahead of the election, that its intention was to fully outlaw the use of what it called exploitative 0 hours contracts. That position has been somewhat watered down, and the bill does not go as far as to ban 0 hours contracts, but it may instead in practice reduce the use of 0 hours contracts. The new provisions on guaranteed hours are complex, so the right, effectively, rather than banning 0 hours contracts, there will be introduced a right to guaranteed hours. I'm not going to go into detail of exactly how that might work in practice, because, as I say, the legislation has been drafted incredibly complex at the moment, and we'll wait to see how that's amended as it moves through Parliament. Employers will be obliged to offer 0 hours or low hours workers a contract for guaranteed hours which reflects their average hours that they would have been working over a specified period. The worker won't be required to accept the offer, and regulations which will be drafted in addition to the Employment Rights Bill are expected to add some more detail as to how this obligation to offer guaranteed hours will operate. However, the duty will apply in perpetuity until the worker takes up the offer or otherwise no longer meets the definition of 0 hours or low hours worker. The proposal also includes a new duty to provide 0 hours workers with information about their rights to guaranteed hours. The bill includes provisions for shift work, which will require employers to give reasonable notice for shift changes and shift cancellations, and compensation will be available for cancelled, moved or curtailed qualifying shifts. Again, we'll have to wait and see what the regulations say as to how this will operate and confirm how much compensation employers will be required to pay. However, we don't anticipate that the compensation will be more than the employee would have got had they worked the shift. As well as rights to pursue claims for non-compliance, there'll also be a new automatic unfair dismissal right in relation to guaranteed hours, including where the employer seeks to avoid complying with the duty to offer those guaranteed hours. So what should businesses do in preparation for these changes? So you could start by auditing the workforce ahead of the reforms taking effect to identify how many workers your business is engaging on a 0 hours or a minimum hours contract. You might also decide to identify whether there's any seasonal fluctuations in demand, where fixed term contracts might be more appropriate, and also review the current system for managing shifts and shift changes. There may need to be consideration for a more sophisticated or efficient system to manage shifts ahead of the reforms. So moving on to post-maternity protection. So as many of you will be aware, since April 2024, women selected for redundancy have a right to suitable alternative employment if they are pregnant or if their expected week of childbirth was less than 18 months ago, which is known as the protected period. The government promised to strengthen those protections, and as a result, the bill permits the government to introduce regulations that will expand those protections to include dismissals for any reason and not just redundancy. Once these regulations take effect, it will mean that employers will need to ensure that any dismissal during that protected period will be for one of the permitted reasons, which we haven't yet been made aware what those are, but likely to include things like dismissals for gross misconduct, or redundancy where there's no other suitable alternative. I think the key point to note here is that the statistics tell us that women are particularly vulnerable during that period of maternity leave or afterwards to dismissal for a variety of reasons, and this is to strengthen the position and the protection for those individuals to address that imbalance in the statistics. In relation to sexual harassment in the workplace, this is an area we've already seen some really significant shifts in the last year. So as many of you will be aware, in October 2024, all employers came under a new duty to take reasonable steps to prevent sexual harassment in the workplace. So this is a positive duty on employers to make sure that they have put in place steps to prevent sexual harassment. If an employer is found to have breached this new duty, the tribunal will be able to award an uplift in compensation of up to 25%, and the Equality and Human Rights Commission has the power to investigate and take enforcement action. The Equality and Human Rights Commission has also published an 8-step guide on its website, which if you haven't reviewed, I would suggest doing so. It's a really practical guide for employers as to how to meet this duty. And it does suggest, amongst other things, training for individuals within the business, having in place a specific sexual harassment policy, and also a specific sexual harassment risk assessment. We are supporting lots of businesses in relation to this duty at the moment, and we'd be happy to support with any policy drafting, or if you'd like to contact us in relation to the sexual harassment risk assessment that we can help you tailor, please do just get in touch with us, and we'll put our contact details up at the end of the session again. The new Employment Rights Bill seeks to expand upon those duties by requiring employers to take all reasonable steps, which does raise the bar significantly, so it's all the more important to start putting in place those steps now. How far businesses will need to go to comply with this expanded duty remains to be seen, but it is an onerous threshold, and it's likely to make sexual harassment claims much harder to defend. The bill also expressly extends the obligation to protect employees from harassment, so all types of harassment, not just sexual harassment, to include liability for third-party harassment. So this is, for example, harassment by a customer, a client, by a supplier or a contractor or any other third party. So this could be particularly difficult for businesses who require their staff to engage with members of the public or with contractors or with other third parties that you don't necessarily have that control over. The bill will also strengthen whistleblowing protections to make allegations of sexual harassment protected disclosures, and therefore also make it void any provision in an agreement which purports to prevent a worker from disclosing sexual harassment. So what are typically referred to within the press as sort of gagging clauses or NDAs, which seek to prevent an individual from disclosing the circumstances of sexual harassment. So that's a bit of a whistle-stop tour of some of the key provisions. I'm going to hand over to my colleague Helena now to pick up on some further points.
Thanks, Siobhan. Yeah, so there's quite a lot of wins there for employees, particularly those who are perhaps not particularly well paid. Not that many wins so far for employers, but the unions have also had a bit of a bumper time of the Employment Rights Bill, and so there's some quite, in some ways, startling proposed changes that are coming down the track in respect of trade unions and industrial action. One of the couple of key points which are potentially coming in fairly quickly, there's the repeal of the minimum service levels, which were introduced only very recently to prevent certain workers from refraining from strike action to ensure continuity of service, and also the repeal of a lot of the Trade Unions Act, which has been in for about 8 years or so, which put certain stipulations in respect of industrial action, such as longer notice periods, higher threshold, higher ballot thresholds, restrictions on picketing, and the expiry of an industrial action mandate after 6 months. Most of these developments look like they're going to be repealed. Just one that's not on the slides, actually, but they're also going to permit trade unions from engaging in electronic balloting, which to date has not been permitted, which is actually perhaps quite sensible, given that we've had personal computers for around 45 years now. So that's perhaps one where we're kind of stepping up to the at least the 20th century in that regard. One quite startling thing is the simplification of the statutory recognition process. This is a process, obviously, whereby unions can apply to be formally recognised, and I've dealt with a number of employers who've managed to push back against such an application, and this is going to make things a lot easier for unions to get recognised if voluntary recognition can't be agreed. This will remove the requirement for a trade union to show that they think at least 50% of the workforce would support the recognition process to even start their application. And there'd also be modernising rules in respect to the final ballot, which at the moment requires a majority, but obviously it also requires that at least 40% of those entitled to vote do actually turn up. So it requires quite a high threshold in terms of people actually bothering to vote. And these changes do away with that, which means that it could be a lot easier for unions to get a foot in the door and get statutory recognition, whereas in the past they wouldn't have been able to. So that's quite a startling development. But the next one's also yes, quite interesting. It's a new positive duty on employers to proactively inform all new employees of their right to join a union. I'm sure a lot of employers would much rather keep quiet about the fact that employees can join a union, but this will actually be a duty on employers to probably include it in their Section 1 statement when they're taking somebody on. It has to be sort of set out that employees do have a right to join. There'll be new rights and protections, particularly for trade union representatives, who obviously need to be able to go about their trade union business without fear of detriment or intimidation or blacklisting. Now, these rights are already quite robust, so I'm not quite sure where they're going with that, but there is talk of enhancing those rights. And another one that I think is slightly alarming for employers that are pushing back against recognition of unions is the right for trade unions to have reasonable access to workplaces. Again, we don't know the full detail of this, but it seems that there will need to be a process whereby they can request access to actually enter the workplace and engage with the workforce, to talk to them about union membership and things that the unions can do for them. And from what I've read, that they don't need to be recognised unions, that they just need to apply. And it may be the case that actually there's limited steps that an employer can take to prevent them from entering the workplace if the unions followed the right process. So again, that is a big win for unions. And just briefly on collective redundancies, another arguably unhelpful development certainly from employers that have multi-sited operations. You'll recall a few years back there was a lot of hoo-ha when Woolworths closed down, and it's been established since then that the definition of an establishment is effectively, I'm simplifying, but essentially a work site. So as long as you don't meet the threshold for redundancies, which is 20 or more, you don't have to engage in collective redundancies. That's changing, and in fact the establishment definition is now going to be the whole business. So you can see that if you've got 10 sites and you're making a few redundancies in each within the same 90-day period, you're easily going to clock up to the 20 or more, which means that there's going to be a lot more collective redundancy consultation that's likely to be triggered going forward. And there's also proposals to make the consultation period for 100 or more redundancies, increasing that from 45 to 90-day consultation period, which is kind of going back to where it was several years ago. Some might say some of this bill is in fact putting things back to where they used to be several years ago. I'll leave that for you to form your own view. And then moving on, there's some changes in the regime of equal pay, which in itself, equal pay is a noble cause, and obviously, you know, one that should be encouraged. But that there are some developments coming down the track that are slightly, I think, going to be very difficult to manage. One of which is that an employer can't effectively get out of paying, let's say, women, but it can work the other way. But let's say paying women less by essentially outsourcing a service. At the moment, an individual who is employed by a subcontractor can't compare themselves to an employee who's employed by the client, the business that's engaging with the subcontractor. And this is looking like it's going to change, which means that actually a set of employees in one organisation that has no relationship with another organisation could compare themselves for the purposes of equal pay. And that I can just see is going to make equal pay legislation and litigation even more complicated than it currently is. I'm watching this one with interest, having done quite a lot of equal pay litigation myself, and just to see how that is actually going to work in practice and what defences an employer might have if they've outsourced and the let's say, you know, the women in the subcontractor are paid less. That's one to watch. There's also perhaps not directly relevant to the audience today, but plans to strengthen the equality impact assessments for public sector bodies. I only mention that really just because, just going back to what Lee was saying, I know we were talking about government impact assessments rather than equality impact assessments, but just given the shocking press that the Regulatory Policy Committee gave about the government's own impact assessments on its own legislation, saying it's not fit for purpose, is just quite eye-opening. There'll be the implementation of a regulatory and enforcement unit for equal pay with involvement from trade unions. I think this is in recognition of the fact that equal pay litigation is quite inaccessible. It's complicated. There's very long employment tribunal backgrounds, backlogs. Not quite sure how this unit's going to work, but presumably it will have, you know, as if there's enforcement powers to try and promote equal pay within the workplace. And then there's a requirement on larger employers to publish action plans. Now, obviously, larger employers currently have to report on their gender pay gaps. And just because there's a gender pay gap doesn't necessarily mean there's unequal pay. The two frameworks are actually separate, although possibly indicative of issues. So that there's that reporting requirement in place now, but this will actually require employers to go a step further and publish equality action plans, which will show how they are proposing to close their gender pay gap, and also, in fact, a wider obligation to show how they're going to ensure equality between the sexes generally. So that might be things like putting in place menopause policies and that sort of thing. So a lot in the world of equal pay coming up. And then moving on, time limits. This has been on the horizon for quite some time, and there was a pledge in Labour's plan to make work pay to introduce an increase in the time limit, the amount of time an employee has to bring a claim. The actual first iteration of the employment bill had nothing on this at all. but it was always proposed, and in fact, in the most the rounds of amendments that were published in November, this now makes an appearance. So the proposal is essentially to say that for most claims, employees will have 6 months from the act complained of to bring a claim, whether that's an act of discrimination or a dismissal, as opposed to the current 3. Now, I think this is a double-edged sword. I think, yes, it is likely to result in an increase in litigation because people have more time to get their ducks in a row and get their claims in. Equally, it gives employers who may be going through a grievance process or other internal process with an employee a longer time to try and resolve things informally without the matter escalating. Often, an employee will have to put in a claim sort of preemptively and escalate matters unnecessarily, when in fact, if they'd had a bit longer, they could have resolved things. So I think it's a double-edged sword. It also means that employers need to be very careful about document retention, on the basis that actually, by the time you add the 6 months and then perhaps a period of time for ACAS, early conciliation, and then the fact that it takes the tribunal often several weeks to get the papers out to you, you could be landed with a claim 9 months after somebody was dismissed. So you need to perhaps review your document retention paperwork to ensure that you could defend any claims if they do come out of the woodwork several months down the line. Moving on. I won't touch on this. You can read this at your leisure when we send the slides out. But this is a useful, handy sort of flow chart just to show the development of the bill. From when it was first proposed back in May to when it was published, and the details of the various consultations that are ongoing. And then there's various things that are happening this year. You'll see that most of the 2025 dates are to be confirmed. There's a lot yet that needs to be clarified in this piece of legislation. But as we said earlier, you'll see that in the purple box right at the end, it's not envisaged that the vast majority of these changes are coming in until autumn 2026. So we do have some time to get our head around it and understand how it's all going to work. So that's the only crumb of comfort I can really give you arising out of all this. And just very quickly, if we just move on, what else is on the horizon? There are a few things that didn't make it into the bill, but things to watch, and I won't go into any detail on these, but things like employment status. There's talk of simplifying the current 3-tier system that we've got, where we've got employees, workers and self-employed. There's a look to simplify that, which would probably align with the tax regime where you've just got employee and non-employee. That there'll be changes to unpaid internships. Possibly they're just going to be stopped. Changes to carers leave and parental leave, and I think Siobhan touched on some of the current thinking behind that and the direction of travel for that. Then there is even talk about changes to TUPE. It's another area I do a lot of, so I should be watching out for those with some degree of trepidation. The right to switch off, that's been largely heralded as a good thing. Again, we're not quite sure how that's going to work, but the noise about that hasn't died down, so that's looking like that is going to be arising. And the last thing, which I'm just going to touch on, the Equality, Race and Disability Bill, if we look at the next slide, is another bill that's sort of in tandem with the Employment Rights Bill. And again, very noble intentions behind this this legislation. I see some significant problems in implementation. The first thing is that they are looking to open out equal pay claims for ethnic minorities and disabled people. There is a pay gap for ethnic minorities and disabled people, just as there is for sort of female and male workers. It's likely to mirror the equal pay regime that we have, but it's going to be much more complicated. I think it's certainly going to increase litigation, and the backlog in the tribunal system at the moment is already almost unmanageable. So although I think it is helpful that if people feel that they are being paid less, and that arises out of their ethnic background or their disability, that they have a way to challenge that, it's going to be hugely complicated to manage. and along with this is a duty to, for larger employers to publish not just their gender pay gap, but their ethnicity and disability pay gaps. Now, again, great in principle. How is this going to work? I mean, gender, quite aside from the wider piece around gender identity, which we could talk about for a long time, gender reporting is ultimately quite binary when you're looking at gender reporting. When you're looking at ethnic background and disability, who are your comparators? You know, there's a wide range of ethnic backgrounds. There's a huge range of disabilities. So there's definitely going to be difficulty in who is comparing, what is like for like. That's going to be very, very difficult, I think, to manage. So, as I said, there's a lot of further detail to come out on this, and we'll be watching this space with interest. So I'm going to pass you back to Lee now, who's going to look at some recent case law, just to take you away from the legislation for a bit of light relief.
Thanks a lot there, Helena. It's a very succinct review of what is a lot of reform there. But do, as I say, do sign up to our updates, and we'll keep you updated as the matters progress. Okay, let's do something different. On to update and recent case law. I've got 3 cases to talk to you about, and I'm going to dive in straight away with the first one, which is the case of Tesco stores and Usdaw and others. This was a case decided by the Supreme Court on the 12th of September 2024, so relatively new. And the case concerned that practice of fire and rehire, which Siobhan talked about. And just by way of recap, it's sometimes used by employers when they want to renegotiate contractual terms, but they face opposition from employees. In essence, an employer will exercise their right under the contract to terminate it and then offer a new set of terms adjusted to the position where they wanted the employee to agree. That practice is, of course, a controversial one, and that's why the current government is committed to ending it, as they say. So the Tesco case is an unusual one, as it demonstrates that a rare scenario where an employer's attempt to force that change is itself said to be a breach of contract. So let me tell you about the facts. So in 2007, Tesco undertakes a reorganisation of its distribution centres, which involves some sites closing, some expanding, and then some new sites opening as well. So a redundancy situation arises in relation to the sites that are due to be closed, and not wishing to lose their experienced employees to redundancy at a critical time when they're expanding and opening new distribution centres, Tesco wants to provide an incentive for staff to relocate. So he therefore negotiates with the recognised trade union, Usdaw, and agreed to an pay enhancement known as retained pay as an alternative to a lump sum redundancy payment. Now, the retained pay is described as guaranteed for life. In communications to staff, Tesco makes it clear that the individual entitlement to retained pay would remain for so long as the employer was employed in their contractual role, couldn't be negotiated away, and would be an increase each year with the general pay rises. So the collective agreement in relation to that is finalised in 2010, and that states that retained pay would be a permanent feature of an individual's contractual entitlement and could only be changed through mutual consent or on promotion to a new role. So roll on to 2021, and Tesco announces that it intends to remove this retained pay, and effective employees are then offered an advance payment of 18 months retained pay to agree to that, or a termination of their retained pay rights. Otherwise, they'd be dismissed and re-engaged on same terms but without that retained pay. So that fire and rehire there. So the claimants are unhappy about that, the employees, so they issue a claim in the High Court seeking declaratory relief as to the nature and extent of the contractual entitlement to retain pay, and an injunction to stop Tesco from removing the contractual entitlement through fire and rehire. And the High Court grants that injunction, and they say that the terms such as protected for life or for as long as you're employed by Tesco in your current role meant that any attempt by Tesco to use fire and rehire was a breach of contract. So Tesco go up to the Court of Appeal, and the Court of Appeal say, we don't agree with the High Court. Effectively, they say there's nothing to indicate that Tesco couldn't give notice to end the contracts in the usual way. So the protection promised was only to last as long as any particular contract. So serving notice to terminate that contract brings that to an end. Well, that's not the last word on this. The claimants go up to the Supreme Court, and the Supreme Court do have the last word, being the highest court in the land. And they allow the appeal and restore the injunction by the High Court. They say there's no implied right to change, and that would make the permanence meaningless. The circumstances in which the right to retain pay was agreed made clear that the offer of permanent retained pay was intended to induce employees to make permanent changes to their lives by relocating to the new distribution centres rather than accepting redundancy. So what do we take from this? Well, the case doesn't signal the end of the practice of hire and refire, but you'll agree that the strength of Tesco's promises on the permanence of that right made this a very unusual case. But it does highlight the need for us advising employers and you as employers to take care when you're negotiating any longevity of contractual terms, and to ensure that in appropriate cases there's the inclusion of a cut-off date that benefits might otherwise be expected to be long-term or permanent. Otherwise, you may find yourself in a position where you have limited rights to terminate the contract to bring about a change later on. You do need to fire and rehire, then there is a code of practice now in place, which came into force in July 2024. And any unreasonable failure to follow that code of practice could result in an employment tribunal uplifting compensation in unfair dismissal claims by up to 25%. And since January of this year, that uplift also applies to claims for failure to inform and consult in relation to collective redundancies. As for the future of fire and rehire, well, Siobhan's already mentioned that the Labour government are committed to end fire and rehire as a lawful means of changing contractual terms, except when there is genuinely no alternative. And businesses need to be able to restructure to remain viable. So an interesting case there, one with some lessons for everyone. The next case on my list is a case of Gallagher and McKinnon's Auto Tyres Limited. And this is an employment appeal tribunal decision from September of last year also. And it concerns the extent of protected conversations, which are allowed under what we call Section 111A of the Employment Rights Act 1996. So Section 111A was brought in 11 years ago. And what it did is it allowed employers to have protected conversations with employees to bring about the termination of employment under an agreed exit, so a settlement agreement normally. And 111A means that those conversations about that would be inadmissible as evidence in claims for unfair dismissal. And this was a real positive step forward, because previous to that, an employer had to rely on what we call the without prejudice rule when trying to have off-the-record conversations. And where there was no claim in contemplation, quite often it was very difficult to rely on without prejudice. So this new type of privilege was well received. So what happened in this case? Well, this case concerned whether or not impropriety was had in the protected conversations. And if there is any improper, unreasonable behaviour, then an employment tribunal can lift that veil of 111A privilege and have a look at those conversations. So Mr. Gallagher's employed as a branch manager, and he went on sick leave in June and July of 2022. And during that sick leave, the company determined that his role was at risk of redundancy. So on his return, he had a return to work meeting, and they used that return to work meeting as a means to have a protected conversation about the termination of his employment with an enhanced redundancy payment rather than commencing a redundancy process. Mr. Gallagher was given 48 hours to consider that verbal offer, and he didn't respond within that time. So a redundancy process then ensued, and he was made redundant. So he brought a claim for unfair dismissal in the Employment Tribunal, and he sought to rely on that conversation in that return to work meeting as inappropriate and improper use of 111A privilege. And to support his claim for unfair dismissal, he wanted to rely on the actions during that meeting. The question really was whether the tribunal could look at those conversations that were had. And the Employment Tribunal had a preliminary hearing, and they decided that they weren't admissible. And Mr. Gallagher then appealed to the Employment Appeal Tribunal, who said, no, we're dismissing this appeal. And the key things for us here is that the EAT said there was nothing perverse in what the tribunal concluded, that the actions of the employer didn't put any undue pressure on Mr. Gallagher. So telling him that a redundancy process would begin if he didn't accept the offer wasn't improper. Inviting him to a meeting to return to work, but then switching it to a without prejudice, a privileged conversation wasn't also improper behaviour. So without giving him advance notice, and then giving him 48 hours to consider the offer wasn't improper behaviour. And that's quite interesting, because there's a code of practice that goes along with these conversations, which normally suggests that you should give 10 days for an employee to consider a written offer. So he was given a verbal offer and only given 2 days, yet still that wasn't deemed improper. So the case is really helpful to employers. It confirms that employment tribunals shouldn't be too ready to find that an employer's conduct in those pre-termination negotiations amounts to improper behaviour. And of particular interest is the EAT's conclusion that the misleading nature of the meeting invitation didn't involve impropriety. So really useful case there, and gives us as employers and advisors some confidence when we're going into these conversations. It's very difficult to pierce that privilege veil. Third and finally then is a case called Thomas and Surrey and Borders Partnership NHS Foundation Trust. Shamelessly, this is one of our cases, so any opportunity to blow our trumpet is much well received. So what happened in this case? Well, the claimant in this case, Mr. Thomas, is an agency worker, or was an agency worker, and he had his assignment with the trust terminated after 2 months because he'd failed to disclose a spent conviction. However, he believed that the real reason for the termination was because he had a belief in English nationalism, and he brought claim in the Employment Tribunal for discrimination on the grounds of religion or belief. And by way of background, the law protects people from suffering discrimination on the grounds of religion or belief. And the concept of what amounts to what we call a philosophical belief is often tricky to establish. And the courts have distilled a 5-stage test in a case called Granger. And so for a belief to be protected, it has to be A, genuinely beheld, not an opinion or viewpoint based on the present state of information, be weighty in a substantial aspect of human life and behaviour, and attain a certain level of cogency, seriousness, cohesion and importance. And important for this case, it also must be worthy of respect in a democratic society, and not be incompatible with human dignity and not conflict with the fundamental rights of others. There's been a lot of case law in this area in the past couple of years, and one of the most high-profile cases we've had is a gender critical belief claim called Forstarter and CDG Group Limited. And that involved Mrs. Forstarter's belief that sex is immutable and a person cannot change their sex from which they were assigned at birth. The Forstarter case clarified that only very extreme beliefs akin to advocating totalitarianism or Nazism would fall outside of the protection of the Equality Act. So what happened in Mr. Thomas's case? Well, we had a preliminary hearing to determine whether his view of English nationalism was capable of being a philosophical belief. If it wasn't, his case stopped there. It's important to note that his view of English nationalism included an anti-Islamic view, and the Employment Tribunal found that that anti-Islamic view was not capable of meeting that fifth limb of the Granger test, being worthy of respect in a democratic society. And in making those findings, the Employment Tribunal referred to the language in which the claimant's disdain for and prejudice towards Islam was consistently cloaked. His use of a hashtag removal Muslims from social media posts was found to be a characteristic of his views. And he actually had a statement saying, "This is why Japan had the sense to ban Islam," as well as his attitudes as reflected in some of his social media posts over the years. He believed Islam in its current form should be banned and advocated coercive removal. So the Employment Tribunal said, your belief's not protected here. He appealed, and one of his arguments in the case was that Employment Appeal Tribunal's decision in the four-starter case effectively watered down that last criterion, and only very, very extreme views are not capable of protection. It lowered that criteria. Well, the EAT disagreed with him, and he said, the EAT, the judge in the case, said that the claimant's belief in English nationalism shared features with an ideology such as Nazism, in which it did not see there being any place within Germany within German society, for Jews. His view in the forcible deportation of Muslims from the UK would undoubtedly amount to a destruction of Muslim practicing people's convention rights. And whilst he was free to hold his own beliefs, he wasn't then able to complain about discrimination in relation to that belief. And the EAT in this case also stated that even though the threshold for the protection is low, there are no errors in the Employment Tribunal's findings that his beliefs do not pass the threshold. So his appeal was dismissed. So what can we take away from that? Well, decisions effectively corrected what seemed to be a misinterpretation of that four-starter case. So very helpful for us as lawyers when we're trying to argue whether something's protected or not. Employees are free to believe whatever they want, but those beliefs may not afford them the right to complain about discrimination. And in light of the recent political climate, this decision should provide great reassurance to many, particularly employers who are striving to implement ED&I strategies. So that's the end of the case law update. And we are now on to any questions from you.
So there's no questions currently that have come in the chat. So what I would maybe suggest is we are running ever so slightly over, so fantastic timing. Thank you all so much. If anybody does have any questions, if you just want to respond to my email, because as I said earlier, I'll be sending an email out that will contain the slides and then a link to the recording on YouTube. And if I can just pass on thanks from myself and also our members. So this was a session that was requested by numerous members, and it's been really helpful and informative. So thank you all so much. And as I mentioned as well, guys, at the very beginning, if anybody does want a certificate for CPD purposes, then just let me know. But thank you.
Thanks, everyone.
Thank you.
Thank you.